Hello everyone. Thank you for joining this morning. My name is Jaya Bajaj and I am an attorney at Farella, Braun & Martel. I specialize in employment issues and my practice is split between advising all types of businesses with their employment issues and also defending employers with various types of litigation.
And I'm Nate Garhart. I focus on trademark, copyright, and online issues. A lot of that online area focuses currently on consumer data and data privacy.
So today we're going to dive into a couple of different topics relevant for wine businesses as we tackle through this new normal, beginning with some legal protocol for safely returning your employees to work, some potential liability that could arise if those guidelines are not followed, and then some privacy law considerations. Next slide. So as you can imagine, there are a lot of different public health authorities that have issued guidance and requirements for trying to ensure that employees are returned to work in as safe of a manner as possible. This includes the state of California and California's Occupational Safety and Health Administration, or OSHA. There's also the federal OSHA requirements and the Centers for Disease Control and Prevention, or the CDC. And then on top of that, there are also local health authorities from your city and county that you will have to pay attention to. So we're going to dive into some of these. A lot of them do overlap, but there are some nuances in each different public health orders that businesses will want to pay attention to. So if we can move on to the next slide. We're going to start with some of the guidance from Cal OSHA. So in general, Cal OSHA requires all California employers to establish an injury and illness prevention program, which helps protect employees from hazards, which includes infectious diseases. So in light of COVID-19, California workplaces are required to adopt changes to their IIPP program since COVID-19 is an infectious disease that is widespread in the community. Next slide. So some of the requirements that employers must implement into their IIPP programs include encouraging sick employees to stay home, immediately sending employees with symptoms home, providing sick leave or expanded family and medical leave for COVID-19 related reasons, ensuring that employees who are returning to work after recovering immediately report any recurrence of symptoms, continuing to encourage telework where that is possible, practicing physical distancing in the workplace, providing and/or requiring the use of cloth face coverings in the workplace, avoiding shared workspaces as possible, ensuring there is thorough cleaning and disinfecting of the workplace, and discouraging travel. Next slide. So in addition to those general Cal OSHA requirements and those updates that must be made to the existing IIPP programs, Cal OSHA has also issued guidance that is specific to different types of industries, including a specific order for restaurants, bars, and wineries. So some of the main takeaways from those industry guidance is that wine businesses must establish a workplace-specific plan, and we'll talk a little bit more about what that plan should cover. They should also conduct workplace training to ensure that their workers are trained on that plan and trained on some of the different control measures that the business will be implementing. And then they must implement those control measures, which includes physical distancing, face covering, frequent hand washing and cleaning, and then training. Next slide. So we talked a little bit about the workplace-specific COVID-19 prevention plan. So this must be a written prevention plan that is based on a risk assessment that the business has taken of its own establishment. It should incorporate face covering guidance and include a policy for handling exemptions for people who cannot wear face coverings due to medical issues. And we will talk a little bit more about that in a later slide. The plan should implement processes and protocols for handling a workplace outbreak. So it should discuss, in the case of a COVID-19 outbreak, what are the business's plans to investigate and implement control measures to prevent a further outbreak. It should also identify contact information for the local health department as required to communicate COVID-19 related information. So this plan must be regularly evaluated and updated. All COVID-19 illnesses must be investigated, and there must be, workers must be trained on the plan so that everyone is aware of what is in it and what's required. Next slide. So what should businesses be training their workers on? In general, they should be trained on COVID-19, how to prevent it from spreading, what underlying conditions might be making individuals more susceptible, how to look out for it. They should also be trained on self-screening at home, so that may include temperature checks and or symptom checks using the CDC guidelines. As many of you may know, the CDC has issued guidance on certain symptoms to look out for, which include fever or chills, cough, shortness of breath, difficulty breathing, fatigue. And to that point, the employer should be trained on when not to come to work. So if they're experiencing any of those symptoms, they should know that it is okay and in fact encouraged to not come to work. They should also know when to seek medical attention. So if those symptoms start to become more severe, including persistent pain in the chest, confusion, blushed lips, they should know that this is time to now take it to public health authorities, seek medical attention. So once those symptoms have subsided, we should provide training on when it's okay for those workers to return to work. Generally, the guidance that has been issued is that it's 10 days after all symptoms have subsided, would be the minimum amount of time after which they can return to work. So aside from the general COVID-19 information, what to look out for, when to seek attention, workers should be trained on hand washing, physical distancing, face coverings, and provided a general overview of paid leave benefits that may be available. A lot of authorities have stressed the importance of this, as many workers may feel as though they can't stay home, so they should be told about their benefits that may be available so as to encourage them to stay home if they really are feeling sick. Some of those benefits include workers' compensation benefits. The California governor has issued executive guidance that any contraction of COVID-19 is presumed to be work-related, which will allow employees to seek workers' compensation benefits if they're to contract the illness. So employees should know what their benefits are, what their leave options are, so that they're encouraged to stay home when they need to. Next slide. So moving on, here are some of the control measures that Cal OSHA has suggested are taken in wine industries in particular. This includes physical distancing, as we've talked about a couple of times. So that is prioritizing outdoor seating, considering takeout where it's possible, ensuring that parties from different households are sitting 6 feet apart, and eliminating person-to-person contact where possible. So this might require some adjustment of layouts, some designation of hallways, which only must be one way. So taking those steps to promote physical distancing to the extent possible. The next thing on here, which we've also mentioned a couple of times, is the importance of face coverings. So people in California must wear face coverings when they're engaged at work, whether at the workplace or performing work off-site. Employers should be providing face coverings to their workers or reimbursing workers for the reasonable cost of obtaining them. Another control measure is providing relevant PPE, so perhaps considering disposable gloves in addition to those face coverings. Implementing frequent hand washing and cleaning. One thing we suggest is building in time for your workers in their shift to practice those cleaning measures. Requiring self-screening or workplace screening. So this is a very important point that has been stressed by multiple authorities. Encouraging sick workers to stay at home, so that kind of goes back to the training piece. Ensuring that your workers know when they should be staying home. And finally, posting rules and reminders. That can include instructions to use hand sanitizer, frequently wash your hands, maintain physical distance from customers, and whenever possible, those rules should also be available digitally. Next slide. So in addition to those control measures, the Cal OSHA has also published specific control measures for tasting rooms. So some of those include using clean glasses for each tasting, not pouring beverages into a glass that customer has already used, discontinuing the use of communal dump buckets, ensuring that beverage container necks do not touch glasses during pouring, staggering tasting group appointments, discontinuing tours that combine groups from different households, and ensuring that tour guides or hosts maintain 6 feet of distance from customers. Next slide. So all the guidance we've talked about thus far has been in the industry-specific guidance for restaurants, bars, and wineries. But if your venue sells beer, wine, or spirits that can also be consumed off premises, you may also want to follow the industry-specific guidance for retail. Producers of beer, wine, and spirits must also follow the industry-specific guidance for manufacturing. And if you have a venue with game operations that are still in operation, then you must also follow the guidance for family entertainment centers. So as Margaret mentioned at the beginning of this presentation, we will be sharing these slides. So I've included the link to the California State website where you can locate all of those different industry guidance. Next slide. So in addition to Cal OSHA, the CDC, federal authority, has also issued some return to work guidance. A lot of it is the same, but to provide some clarification, I've included some of the main takeaways on this page. So it includes daily health checks, a hazard assessment of your workplace, encouraging again the use of face coverings, improving building ventilation to the extent possible, so that may require installing some new air purifiers if certain operations can't be conducted outside, implementing a strong social distancing policy, ensuring frequent hand washing and cleaning, modifying layouts, staggering work shifts, posting signage, designating a point of contact in the case of any outbreaks, worker training, and flexible sick leave policies. Next slide. So in addition to those federal and state guidances, there's also local guidance that businesses will have to pay attention to. So please be sure to check your county and city guidelines. As an example, in Napa County, in addition to the state requirements, they have issued a recovery roadmap, which includes posting a checklist and posting a social distancing protocol. In Sonoma County, they've issued a best management practice plans and a plan specific for restaurant, retail, and hospitality industries. In San Joaquin County, they've issued an employee health protocol. And in San Luis Obispo County, they've issued a reopening and self-certification process, which, similar to Napa, also includes a checklist and other self-certification forms. So please check your county and city guidelines. I've included links to some of those guidelines on this page. Next slide. So you may be asking after all of this, what is the risk if those guidelines are not exactly followed? So one of the big ones is workers' compensation risk. As I mentioned earlier on, if a worker contracts COVID-19, there is a presumption of work-relatedness, which would allow them to obtain workers' compensation benefits and file a workers' compensation claim. So it's very important that businesses are taking these safety guidelines seriously so as to ensure workers' compensation risk, so as to mitigate workers' compensation risk in the future. There's also the risk of OSHA enforcement actions. Employees can contact the OSHA department, Cal OSHA, or the federal OSHA and file enforcement claims. In addition, if they make any complaints to supervisors, managers about CDC or OSHA directives not being followed, and then any subsequent adverse action is taken against those employees, there is a definite risk of whistleblower retaliation and wrongful termination in violation of public policy claims. And in fact, we've already seen cases along those lines being followed. For example, when an employee expressed concern about employees with symptoms coming to work or inquired about lack of gloves and subsequently thereafter faced adverse action, they filed a wrongful termination in violation of public policy claim. There's also similarly a risk of constructive discharge. So if an employee is raising concerns, safety concerns about CDC or OSHA guidelines not being followed and thereafter resign, they may have valid grounds for a constructive discharge claim. In other words, they felt that they had no option but to resign because of these safety issues in the workplace. Next slide. So another thing to keep in mind is employee privacy and medical issues, and Nate will be diving in deeper into some of the privacy issues, but from an employment perspective, the Americans with Disabilities Act and state laws prohibit disability discrimination and provide certain rights to medical privacy. That includes restricting inquiries about medical conditions and regulating medical examinations. In light of COVID-19, the Equal Employment Opportunity Commission and the Department of Fair Employment and Housing in California have provided guidance that allow employers to make certain inquiries which may normally not have been allowed due to ADA regulations. So now employers are allowed to ask about employee symptoms, but they must maintain that information as a confidential record. They can take temperatures to evaluate risk of their employees staying in the workplace. They can ask their employees why they're absent from work. And if their employees have been absent from work, they can require a certificate of fitness to return to work. Next slide. That being said, we suggest that employers rely on judgment and recommendations from healthcare professionals rather than strictly requiring documentation certifying COVID-19. In terms of requiring COVID-19 testing, it is allowed as long as the employer can show that it was job-related and consistent with business necessity and that the testing was accurate and reliable. We do suggest that employers avoid antibody testings partially due to risk of them not being reliable and because they may be viewed as an unlawful inquiry into medical history. Employers can notify their workforce, can and should notify their workforce of exposure, but they cannot reveal the names of impacted employees. The California DFEH has issued suggested language on how to notify your workforce about an outbreak, which I've included a link to here. It is fairly vague. It says that an employee has tested positive for COVID-19. It includes the date that they tested positive, and it includes a notification that they may have potentially been exposed to COVID-19. Next slide. So lastly here, I have a reminder about medical records. These medical records must be stored separately from personnel files. So it should be a separate medical file that you're maintaining for your employees, and access to those medical files should be confidential and limited. COVID-19 related medical information can be incorporated as part of those existing medical files. So that includes any statement from an employee that he or she has a disease or suspects that he or she has a disease, and any notes questioning employees about COVID-19 symptoms or related activities. So if you're engaging in a self-screening process, those notes should be incorporated as part of the medical file. Also, the Health Insurance Portability and Accountability Act, or HIPAA, privacy rule does require covered entities to protect individuals' medical records and personal health information. So out of caution, treat all medical information, including the identity of infected individuals, any disclosures about symptoms, as confidential. And with that, I'm going to turn it over to Nate to dive a little bit deeper into some of the privacy legislation.
Great, thanks, Jaya. So earlier in the pandemic, there was a lot more consideration when looking at guidelines and putting together guidelines. There was a lot of thought that there would be a lot of data collected from employees, from consumers. There was talk of location tracking of employees in order to identify where they've gone, who they might have come into contact with, etc. There was also talk of contact tracing with consumers. So a consumer would come in, you would gather information from them, and then if somebody was diagnosed with the disease, you would go back, find where they'd been, connect who had been there at the same time, and that kind of information. All of that would have created some heavy lifting as far as data privacy. Whether you think it's a good idea or a bad idea that the guidance has gone a different way, the fact of the matter is you're simply not going to be collecting as much data from consumers or even from employees as you might have been required to in the different situation, which in fact, Europe and the UK have both begun implementing. So there's a lot more data going on over there, data collection going on over there than here. If you look back at what Jaya talked about, there were very few examples in those identified guidelines and identified actions to take that involved collecting data. In fact, the only ones I saw were the health screenings and potential temperature checks, although the temperature checks were brought up in connection with the ADA and what you may do. None of the guidelines themselves suggested that you take the temperatures of your employees or your consumers, your customers. So it really seems like there's not going to be a lot of specific data that's collected, but that doesn't mean there won't be any data collected. For example, with those wellness screenings, when somebody shows up for work, you may be documenting whether that person was well or not, things like that. If somebody does get sick, you may be documenting that they have the disease or had it at a certain time. So you may collect some information, and it's important to know that that information, to the extent that you collect it and use it and store it online, any of those, it will be subject to certain legislation and certain requirements. So let's talk about the laws that are implicated. And Jaya just talked about the ADA and HIPAA, so I won't go into those. And really, they're really about keeping that information confidential. I'm going to jump to the bottom now, that pending federal legislation. There are competing bills from the Democrats and from the Republicans, and it looks like neither of those bills is going to go anywhere anytime soon. Not surprisingly, nobody's able to speak on a level that will get something moving forward on this. So that pending federal legislation, at least right now, not a concern. The Illinois Biometric Information Privacy Act applies to employees in Illinois. So I just put this on here because in connection with COVID, I've heard this law come up many times. And the fact of the matter is, if you're not an Illinois employer, this will not apply to you. If you're not employing Illinois residents, it will not apply to you. So that leaves us with the California Consumer Privacy Act, the CCPA, which I expect you've heard a lot about. So the first question is, does the CCPA apply to your company? Is your company subject to its requirements? And it's a three-pronged test to determine whether it applies. If you satisfy any of these conditions, you are subject to the act. The first condition is if you have revenues of $25 million or greater per year. So if you have revenues of $25 million per year, you're subject to the act and you need to comply with the requirements. The second possibility is even if you don't have revenues of that level, if you collect data from 50,000 or more consumers per year, in that case, you would be subject to the act. And the third one, which is much less likely, is even if you don't satisfy either of the first two, if you make half of your revenues or more from selling personal information, then you would be subject to the act. Obviously, that's not likely for the people on this call and for most companies, frankly. So the bottom line is, again, it's that $25 million threshold, or that you collect the information from 50,000 or more California residents per year. Next slide, please. So what is the CCPA about? The CCPA is really about putting into action the general privacy principles that people have come to expect in connection with their own personal data. First of all, people feel they have a right to know before anything's collected, what is it that you're collecting? That is the categories of information that are being collected. And what are you doing with it? Are you sharing it with others? If you are, I want to know about that. And so I want that to be disclosed to me before I provide information to you. The second is the right to control my information. And that is the accuracy of the information. That is, I want to be able to contact you and say, hey, the data that you have on me is incorrect. I see in this email that you have my address as X and it's actually Y. Obviously, there's a good reason a company would want to keep that information accurate as well, but it is a requirement to enable that under the CCPA. The other right to control is to be able to get a copy of all the information that's been collected on me. So if I write to you and say that I want to know everything you have on me, you have to provide that to me. And in connection with that, I can also request a deletion of all that information, that is the right to be forgotten. Next slide, please. So where is it that you could be dealing with new data or a new situation in the COVID area that you haven't dealt with before? First of all, with employees, you might be collecting some new data. Again, you might be collecting information about, is somebody well on a given day? Does somebody exhibit symptoms on a given day? If you're collecting that information and you're adding it to their electronic files that you hold in the cloud, that information, again, if you are subject to the CCPA, that information would be subject to the requirements of the CCPA. And in connection with that, you suddenly would have to give that privacy disclosure before you collect the information. So if you're going to start screening employees, whether it's temperature checks, whether it's symptom tracking, that is just noting whether somebody is showing symptoms, and you're going to store that electronically, you're going to have to provide the privacy disclosure. Now, how can you do that? Well, you have a couple options. First of all, you could post a simple privacy disclosure, physically post something where you are collecting that information from the employee. So if it's at the entrance, the employee entrance, it could be in that room, something that just makes clear that you're collecting, storing this information, and that it will be subject to your privacy policy that you have otherwise provided to the employees. Second option would be to hand people a sheet of paper that has that information. But in one way or another, you have to give employees notice that you're collecting this data and storing it electronically, and what purposes you're using it for at the time that you collect that data. Same thing with consumers. Again, we're not looking at contact tracing anymore. It doesn't seem to be the direction things are going, and certainly the guidelines are not requiring contact tracing. So in connection with that, it's really unlikely you're going to be collecting much consumer data in connection with the current pandemic. But if you were to collect data, you certainly would need to do that same privacy disclosure at that time. If you're taking somebody's email address and adding to it the times that or days that they attended a tasting, and you're storing that information, you need to give the consumer notice that you are now taking additional information from them that is personal to them. Again, their whereabouts on a given day. That, if it's coupled with their identifying information, that would amount to personal information and would trigger the requirements of the CCPA. And again, that privacy disclosure could be posted at the time you're collecting that information, or it could be something that, say, you hand out menus or a tasting sheet, you could provide it on that sheet as well. That would be another option. Next slide, please. So what are the best practices? Again, we're at the point now, I've covered what we need to really know about the data in this situation. So what do you need to do? The first is pretty straightforward. Don't collect more than you need to collect. If you are truly going to do contact tracing, then collect information for it. But if you're not, and you have no need for that data, certainly don't do it just for the sake of doing it. It just increases risk that you trip up somewhere along the line. Again, as I mentioned before, you want to provide a privacy disclosure at the time you collect the new information, or at the time you determine you're going to use existing information differently. So what's an example of that? I have your email address, and I've told you in my privacy policy that I'm going to use that email address to contact you. Well, I've now decided I am going to do some contact tracing, and so I'm going to use your email, couple it with your dates of attendance, and I'm going to use that to determine if I need to have concerns about your wellness, or if you turn out to test positive at some point, that I need to notify others that somebody was at the winery at a given time and they need to know that this person tested positive. But at any rate, to use your email then to notify you, for example, that somebody tested positive on the day you were at my winery, that's a new use of your email. That's a new type of communication that I did not disclose to you in my privacy policy that was going to be a use of your email. And so that's a new use, and that new use needs to be disclosed at the time that I'm collecting the information, or that I plan to use that information differently. And so again, when somebody's visiting the tasting room, that's a good time to either post this information about your new uses, the privacy information, or to hand them something that includes just basic information on the fact that you're going to be collecting different information or using information differently. Next slide. If you're storing data online, and that's the only time it really matters as far as the California Consumer Privacy Act, but you want to anonymize that data where possible. So if you don't need the dates somebody was there to be connected to their email, for example, then don't connect it. Suddenly those dates are merely anonymous information, and that does not have to be protected, doesn't link to any person, really doesn't have any concern or risk associated with it. That said, obviously, where it's anonymized, it's less useful for certain purposes. Secondly, you want to ensure data security. The best way to do that is to encrypt data. If you're storing data online, while encryption is certainly something beyond my abilities, if you're storing data online, you're probably using a third-party service, or you have an internal IT department that won't have a problem making sure the data is encrypted and thus much more protected. And finally, you want to delete that sensitive data, for example, somebody's health condition, when it's appropriate, that is when it's not an issue anymore, and you're no longer required to have it. There could be situations for insurance and other purposes that you don't have a particular need for it, but you are still required to hold that information. And that would depend on other policies to which you're required to agree. Next slide. So that's all we have today, and we appreciate you coming.